Welcome, everyone. At this time, we'd like to thank the Police Credit Union for sponsoring our lead series. For over 75 years, the Police Credit Union has been providing financial solutions to take care of our own, exclusively serving law enforcement professionals and their family members throughout California. They proudly provide banking solutions, including checking accounts, home and auto loans, credit cards, online services, and more. As your financial partner, the Police Credit Union is committed to helping you succeed financially, whatever your stage of life. We want to thank the Police Credit Union for being our exclusive one-source premier financial partner and for sponsoring our lead series. My name is Tariq Bruno, and I'm CPOA's membership coordinator. We welcome you to our November session of our Leads Conversation Series, which was created immediately upon the onset of this pandemic last year so that the profession could stay connected. As membership coordinator, I serve as liaison to our 12 regions, and I wish to thank our Region 6 for bringing you today's topic, investigating fentanyl overdoses as second-degree murders. Region 6 represents Inyo, Riverside, and San Bernardino counties. So with that being said, I will turn it over to Sergeant Steve Brochet of the Riverside County Sheriff's Office to begin.
Good afternoon. Just wait for the screen to be shared here in a second, but to begin with, like you said, my name is Steve Brochet. I'm a sergeant currently assigned to the Central Homicide Unit with Riverside County Sheriff's Department. Prior to that, I ran a local station bureau, Lake Elsinore Station. Before promoting to sergeant, I was assigned to a gang task force. And then prior to that, patrol, and actually started with San Diego PD before lateraling up. So with that, we can begin. So this presentation, obviously, it's divided up into two pieces. The first will be kind of the law enforcement side, and then the second will be given by DDA Jerry Full. We'll get more into the legal courtroom type side. So this all began late December 2019 for us. We noticed a very large increase in fentanyl deaths within Riverside County. As you can see there, in 2017, 2018, we doubled. 2019, we doubled. Statewide was at 1,603 deaths. And then in 2020, we were up to 227 deaths. In 2021, in April, we were at 42, and then in August, we were at 161. This is the same presentation that Jerry and I gave at CHIA, so that's why the date was ended in August, but obviously that's going to be much higher due to delays in toxicology and things like that from the coroner's office. So we realized we had a problem on our hands. Again, December 2019, this kind of began coming to light with when Alexandra died. She was a 19-year-old from Great Oak High School, died from acute fentanyl poisoning. She believed she was taking an M30 pill. So Melissa Melendez had introduced a drug-induced homicide law. However, it did not pass committee. If you believe in the drug-induced homicide law, the argument behind it is that once a seller or a suspect can shown to have known that fentanyl, how dangerous it is, you could then possibly prosecute them for a second-degree murder. However, it failed. The opposition believes that the sellers are just as much victims as the victims, and we should not be treating sellers as suspects. On top of that, they believe that it's less likely that a lot of these fentanyl deaths occur with friends, with romantic partners. It's less likely that someone is going to call 911 and help a victim if they believe they may be charged with a crime. So with that, the introduction here, we're going to go through the investigative response. We're going to go through the training that RSO put together. We're going to then go through briefly the legal side, more as it pertains to what we're looking for on the law enforcement side, so that Jerry can have what he needs for a successful prosecution. The big crutch of this was changing the culture. Go ahead there, Jerry, you can click the next one. We'll also go through some recent cases. So that being said, what I mean by changing the culture is the patrol response that a lot of us may be used to as it pertains to an OD is if the person lived, we might not even end up showing up to the call. Patrol may just hear from fire that they transported them. It's most likely they're going to live. We may not even show up. There was no interviews done. It was on to the next. If indeed a person did die of an OD and you responded, it was take some photos, you're calling the coroner, you're trying to get in contact next to kin. But if it's clearly an OD, other than collecting maybe some obvious illegal drugs, you're not doing a good search of the house, you're not dealing with phones, you're not dealing with witnesses or family members who may be at the scene. So it's about changing the way they deal with the response so that 3 weeks later, we have what we need on the back end. The investigator response is that next level of investigation that patrol is either not prepared for or just doesn't have the experience for. The search warrants, the expertise with interviews, the ability to recognize that maybe we have something more here than just an overdose. And even that begins to then rise to the next level of possibly a major narcotics team involvement, or a next level dope team that has the ability to do buy busts, undercover work, things like that, that maybe a station level investigator doesn't have the ability to do because he's carrying a caseload of different frauds and things like that. So we needed to put together a response that everyone assisted with, so that we got the outcome that we needed. Go ahead, Jerry. So then if the narcotics teams were able to work backwards and locate a possible dealer, possible fentanyl dealer that we could directly relate to our victim, then they would call our homicide bureau that would assist with interviews and anything we may need on the back end. Now, I will say that towards the end of this presentation, this has already changed a little bit. This is a very fluid situation right now for Riverside County Sheriff. Since then, I'll get into it a little later, we've actually created our own OD task force, but I'll get into that a little bit later. So these NARC teams will then communicate with the DA for filing right on the front end, much like we do with a homicide where we have our homicide DAs come out with us right on that initial call. Go ahead, Jared. So the training. We went around to each stations and also did what we call a doc read, which is, I'm sure every department in here has something similar to it, but it's an email blast that goes out to everybody. There's either a quiz at the end of it, or they have to acknowledge that they understand it. On top of that, we went around and did station level training with the department-wide investigation sergeants and the detectives so that everyone was on the same page. So some things that we brought up to the deputies. When deputies arrest a fentanyl dealer or respond to a deceased person, they need to throw the old way out the window. Station investigators should be notified for search warrants related to phones, video surveillance, medical records. Interview all people present to obtain background information on the victim decedent. This is important because you learn about their drug activity. Are they someone who a year ago was in a car accident and they're strictly looking for perks, and now all of a sudden they have a laced fentanyl pill that's stamped with an M30? Documentation of all other narcotics found at the scene. Is it strictly fentanyl pills? Is it a multitude of different narcotics found at the scene? So first time, long time users, are they present for overdoses of friends? Or have they been a victim of their own overdose? This all goes to show implied malice later on. Again, what the victim was intending to ingest, that would definitely be a gold standard if we could somehow prove that they had no intention of taking fentanyl. They wanted a Vicodin or something else. A lot of times the witnesses or the people's friends may give up their dealer. Their parents may give up their dealer or a friend who they think they may have dealt with. We've actually had a lot of luck over the last year with people coming forward when someone dies so unexpectedly. And again, preservation letters from social media accounts are huge. A lot of these, especially the younger kids, are using Instagram and social media to set up these drug deals. Go ahead, Jerry. So we didn't just throw it on the deputies. We also made sure that the supervisors had some accountability to this. So when the deputies called their patrol sergeant and said, I have a fentanyl OD, the bells and whistles start going off for that first line supervisor that I may need to make that next level notification. Do I need to be contacting major narcotics? Do I need to get a DA on board quickly? Major narcotics can, if they can come out and they can debrief somebody very quickly, they may be able to turn them right then and there. The other big thing was if an advisement was given, the supervisors need, which I'll get into in a second here, the supervisors need to make sure that was documented in some way, either in body worn camera fashion, a note in a report, even worst case scenario, an FI. I know a lot of agencies are really good with FIs. Gang teams are really good with FIs. And that can be brought up later on, and it can still be very helpful to show that an advisement was given. Obviously, the gold standard is body-worn camera, but sometimes that doesn't always work out. And then just to forward the notification to our Major Crimes Bureau or Special Investigations Bureau that run our narcotics. Go ahead, Jared. So this is our fentanyl advisement. We cleared it with our DA's office. I'll let you guys read it. I won't read it verbatim, but I know I've handed this out to a few different agencies. The basic gist of it is that fentanyl is something like no other narcotic. And selling and furnishing it can cause someone to die in an instant. And that furnishing these drugs, distributing drugs to someone can result in you being charged with murder. This is our doc read. I can tell now it's a little hard to read, so I apologize for that. So if you guys want a copy of this, I can give it to you. But essentially what it says is these three things that we just went over. It gives the advisement, it gives the patrol officers and the investigators responsibilities and things they need to double check when they're out of the scene. And then it gives the supervisor responsibilities. A lot of guys have said that they just throw this advisement or this doc read in their gear bags and pull it out when they need it. Some guys have cut it in half and laminated it. So just little, I guess, a tip there. The important thing is getting the advisement out to the guys on the ground, the dope teams, that when they catch somebody with a couple pills of fentanyl, they can give this guy the advisement and they can make sure that we're getting out in front of it. Go ahead there. Okay, so second degree filing. So what we're looking for here on the law enforcement side is what we want to give the DA is we want to show that malice is implied, and malice is implied very similar to a Watson advisement when it comes to a DUI. When the killing results from an intentional act, the natural consequences are dangerous to life, or this act deliberately performed by a person who knows his conduct endangers the life of another. And then the Watson advisement, where this came from, the theory that the DA's office is working behind on this one. So just as a person who may get into a DUI and upon conviction, they're getting this Watson advisement, they know that driving a car while intoxicated is an intentional act that threatens life. You've turned that car into a deadly weapon. And now we can show that the defendant was aware of those hazards, just like we can with fentanyl. And that person can then be charged with a second degree murder related to DUI when they run in and kill that whole family. That's the legal theory. So if we don't have that advisement, how does law enforcement show implied malice? So there's a few ways here that we go about doing that. And we've done this in actually 4 cases. And Jerry, I'm a little removed here, so correct me if I'm wrong. We're up to 4 cases now where we've got filings. And some of the specifics in these cases have been Narcan at the house, That is huge. These guys, we've been told, are having Narcan parties where they will all line up and the first person will take the fentanyl. And if they do good, then that second person will then give the Narcan to the third person. And that second person will then take the fentanyl, and so on down the line. So that they've even placed fail safes into the way they deal with fentanyl because they know it's so dangerous. So if you can show Narcan at a house and you can get a statement from somebody at the house that this is why we have it, that's great. Great to show dangerousness of the drugs. Prior ODs are huge, whether it's the person who the seller has OD'd or he was at a house where someone has OD'd. Knowledge of prior ODs involving death. One case we did a particular amount of work on going backwards, and we were able to actually show that our suspect was on body-worn camera a few months earlier, present during an OD where he had said, you know, yeah, she had just taken fentanyl a few minutes ago, and now she's OD'd. Let's see. So prior suspects arrests. During those arrests, was an advisement given? It's not the first time they've been arrested to show the danger. Cell phone text messages and social media is huge for those same reasons why I spoke about earlier. Witness statements at the scene telling you, you know, what they're involved in, what they're not involved in. Next to kin phone access. So this is something that everyone needs to talk to their DA's office about. Our DA's office they're under their guidance is that if you are at a home of, let's say, a 16-year-old who ODs and mom or dad has next to kin access to that phone, or a wife or a husband has it, and we jump into that phone pursuant to a search warrant to see if we can find a specific text message about a deal, we're okay, as long as we follow that up with a search warrant. And Jerry, again, correct me if I'm wrong, but where we begin getting into an iffy Cal ECPA area is if we are then going into social media and then going into a possible suspect social media once removed. That we probably need to wait and grab a preservation letter and go about it that way with a search warrant later on. But please check with your DA's office as to their opinions on that, because they're going to be the ones litigating that later on. So again, another big question that tends to come up is we need to remember that the victim can contribute to his or her own death without absolving the defendant's liability. So what that means is that if a dealer sells to someone, we need to remember that the defendant's furnishing of fentanyl was a substantial factor in the victim's death. And it's possible, as I'm reading here, and foreseeable that someone would have consumed the fentanyl furnished by the defendant. If he didn't specifically sell to him, that's fine. At some point, it's foreseeable that someone will use that fentanyl. We get a lot of these where maybe the boyfriend buys for the girlfriend and then provides for the girlfriend. The only way where this may change is that if there's an independent intervening cause. And the example I've always been given by our DA's office is if someone ODs, they're being rushed to the hospital, they end up getting into an accident in the ambulance and die. Or the doctor does a surgery and severs an artery and they die. There has to be something else there. Go ahead, Jared. So other filing options to remember, DDA full, we'll get into People versus Ollo in a second here, but if you can't find your unicorn case, which is what we called it when we looked for it, we needed to have a lot of things present in order to get a filing on these cases. And we actually threw a lot out as we were reviewing these over the months. There were a few jail ones that we had to throw out just because we couldn't connect that third, fourth, and fifth party transporting. But keep in mind your federal partners have a GBI filing. Go ahead, you can hit the next one, Jerry. And they have significant time for fentanyl that we just don't have on the state side. So we do have task force members that are cross-sworn with the DEA. So if you have a real problem with a specific suspect or a specific gang, don't forget to reach out to those task forces that can provide you with the ability to possibly file federally. So I won't get into a lot of the specifics with the case study, but essentially all of them had one of these or the majority of these in common that we were able to prove up with our first 4 cases. We had multiple ODs at a residence. We had records checks where we were able to show that people had OD'd and both lived and survived at one specific residence. We were able to tie these back to a dealer at another residence. Interviews and UC work were huge, which is the need to get everybody involved. A homicide unit most likely is not going out and doing UC buys. The same way as a station level bureau or patrol are usually not doing UC buys. We had hand-to-hands with a narcotics unit selling after our advisement was given, after an arrest, after being able to show that people have already died from his fentanyl, continuing to sell fentanyl in a hand-to-hand. Sales cases are great to obviously prove that he's selling. The advisement, the cell phone records to show location, CDRs after the fact to show where he's going and where he's selling. If you can show that he's constantly going to a known dope house through CDRs, that's big. And one of our big aha moments was we had friends of a victim imploring a suspect not to sell. He doesn't know what he's doing with these. He's quote unquote popping them like candy. And just imploring the suspect not to sell to this kid anymore. And he continued to sell. So again, lessons learned, social media preservation letters, really big. You got to get on top of those right away before they delete them. You can backtrack dealers through victims' cell phones. Test the drugs, don't destroy them. Our narcotics teams have sent fentanyl back to DEA for Quantico to actually get a chemist to take a look at the potency. I don't think DOJ normally does it in California for us, but I believe under certain circumstances, DEA will agree to do it. Presence of other drugs, Perkins operations. So we were successful with one Perkins operations we did on these. I'm picky when we do decide to do these. And the only reason being is usually we have enough, and usually we found that our witnesses are talking to us. Even our suspects have talked to us in almost all of these cases. And we have to remember with Perkins operations, with the litigation that goes on the back end of these throughout the court process, we don't want to unnecessarily expose ourselves to unnecessary litigation. One note, be careful if you don't have enough and you want to run a Perkins operation on one of these. Through discussion with our coordinators, we've kind of, we want to be careful with how do you corroborate their statement. So in a Perkins op, let's say they admit to an agent that they did indeed know that it was dangerous. Well, how do you really know that their state of mind is of the fact that they know that it's dangerous? How do you corroborate that without text messages, without social media, without somebody telling you something else other than just that one fact? Is it good? Yeah, but I could see a defense attorney bringing something up about how did you really corroborate my client's state of mind? Okay, you can go ahead to the next one. So another lesson learned, we found that we really don't need to process these scenes like a homicide. Even if you think you're going to get a second-degree murder charge or something close to it, there's usually not the DNA evidence present that you may find at a homicide scene. You're not looking at trajectories. You're not looking at casings being picked up and matched to, ballistics of a gun. There's just a lot of things that you're not looking for at an OD. We've found that it's something that an experienced investigator doesn't need to go through the process of calling out a homicide investigator to look at an OD scene. We're going to want you to look for the presence of other drugs, collect cell phones, speak to witnesses. That seems to be vastly more important than those other things. But just go back one, Jer. Again, you've got to have buy-in from your teams if you're going to work one of these collectively. And then the toxicology, presence of other drugs. Our coroner's office has said, even if it's fentanyl mixed with meth and heroin, his finding will always still be acute fentanyl poisoning, because in his medical opinion, there is nothing that killed this person other than that fentanyl, for what it's worth. Please check with your coroner's office, your forensic pathologist before going forward with that. And then again, so this is what it's kind of morphed into. Homicide has kind of taken a back step to this now that it's ramped up, and we've created an overdose task force. It's assigned 2 investigators, a sergeant, actually 3 investigators now. And they also have a federal partner with our DEA. But the big thing we noticed with this is the narcotics guys and the station level detectives were doing almost all the work on the front end. And then when they had a good case, they were coming to us prior to an arrest. And all we were doing was advising them on certain questions to ask for or what to look for implied malice. So what we did was we threw an experienced prior homicide investigator on that team. And it seemed to really work out. He's able to guide the questioning of the younger investigators and still bringing several cases to the DA. So with that, I will turn it over to my partner, Jerry Full.
Good afternoon, everyone. Thank you so much for having me today. And in a moment, I'll be putting up my presentation. So bear with me on that as that comes up now. But all right, there we go. So my name is Jerry Full. I'm a deputy district attorney with the Riverside County District Attorney's Office. And so for the next about 30 minutes, we're going to be talking about prosecuting these cases as well as general awareness. Quite frankly, there is probably a wide range of law enforcement experience in this room. We have individuals who are probably well-versed in the investigation of major narcotics, as well as homicide investigators. But considering that this is a nexus between those 2 genres, it's important to start from the beginning. And through Steve's presentation, you already saw these numbers specific to Riverside County. Riverside County has seen an annual doubling of our deaths due to acute fentanyl poisoning. And let me tell you something right now. For any person in this training, in this conversation, who is working specifically in this area, and you've come in contact with parents of those who have lost a loved one or friends of a loved one, I'm going to tell you that classic phrase of overdose is something that we're evolving the definition on. Like Steve mentioned, we're treating these as poisonings. And the phrase overdose has a natural stigma to it. We might consider overdose consistent with people who have long-term drug abuse, who are maybe homeless, or who are experiencing the long-term deterioration based upon repeated drug use. But here, there quite frankly this is a substance unlike anything we've ever seen before. And so for that reason, and also for not only respect to those who have lost individuals to this drug, and also for legal reasons, which we're going to discuss momentarily, these are poisonings. And to be clear, it takes 5,000 milligrams to make a teaspoon. A lethal dose of fentanyl is approximately 2 milligrams. There is, hopefully it shows up okay on your screen. If it doesn't, it'll be better in the next one. Comparing the lethal dosage of fentanyl to the size of a penny, it's the equivalent of about 5 to 7 grains of table salt. It is an extremely small amount that will kill an average person. And so approximately 1/5 of a single teaspoon, one is equivalent enough to cause 434 deaths. One lethal overdose, 1/2500th of a teaspoon, 2 milligrams. It is a insanely small amount that will kill a person. And so with that, the plagues that are coming into our community and that you probably are all most familiar with are the M30 pills. And so a little bit of a background, which some of you, if not all of you, already know. America has been suffering through an opioid crisis for the last few decades. And we are currently in the third wave of that crisis. The way the crisis started was with the overprescription of prescription opioids. And we had a number of people who, when they no longer needed that oxycodone, their knee was healed and they weren't taking the pills anymore, they found that they could be abused. Or likewise, people in their family or other persons who had access to the medicine cabinet were taking them, not for pain relief, but in order to get high. And so once we saw a tightening up of prescriptions, people then turned to illicit forms of opioids, specifically heroin. The third wave that we are seeing now started with the use of the synthetic opioid fentanyl, which, unlike heroin, which is derived from the poppy plant, the synthetic opioid of fentanyl can be made anywhere from chemicals. And so because of that, you don't have the overhead costs of harvesting the plant, of processing it, of doing all the things that are required that you would on heroin. Also, more importantly, fentanyl is exponentially stronger than other opioids. It's 100 times more stronger than morphine. It is 50 times stronger than heroin. And so what everyone quickly found was that this was a substance, and in relatively small doses, could create a high that drug users sought. And likewise, when it was initially disguised in these oxycodone pills that were in high demand, you had a ready market for it. Now, one little secret, one actually very unfortunate thing that I want to share is that while there are still many people who are taking these M30s believing that they are, in fact, oxycodone, we also see that this has become a brand, that M30s, blues, 30s, these are now substances that people know contain fentanyl, and they are chasing that high. Quite frankly, as we're going to discuss momentarily, and is going to become more pertinent as we go through the legal analysis on this, you can look at it in terms of Goldilocks and the Three Bears. These pills quite often either have no effect, the perfect effect, or too much, and it will kill you. And remember, too much is as little as 10 milligrams. So quite frankly, the percentages of death and destruction that are coming from this pill and other forms of fentanyl are amazing. And I don't want to scare anyone off of the prescription hospital setting of fentanyl. That is not what is destroying lives in our communities. It is the illicitly made that is being smuggled into our country in a number of different ways. And so additionally, aside from the counterfeit pills, we're also seeing it in powder form. Powder form is the most common way that it is smuggled into the country and then cut into stronger drugs, or excuse me, other drugs. I shouldn't say stronger, because fentanyl is stronger than heroin, cocaine. But nonetheless, they're seeing it put into these other drugs because not only does it make those drugs cheaper, but it creates something where we are now seeing a more desired high at a lower cost. One thing I do want to take the time to say is, as Steve mentioned, when we see pushback from our legislators, from lawmakers with regard to fentanyl specifically, we are not seeing this in a vacuum. This is not a victimless crime, as demonstrated more easily by the fact that we have hundreds and thousands of people dying nationwide from this specific drug. But what you're seeing here is quite commonly the firearms, the mass packaging of drugs, a life of destruction on a table right there for you. And by the way, one other hiccup in the law, which will be not discussed here, as our main focus is focusing on those who've died or who have been suffered great bodily injury as a result of the poisoning of fentanyl. But currently, under the operational law, the possession of a firearm with a controlled substance, I believe that's 11-370.1, it doesn't apply to fentanyl, which if you have another drug that is mixed in, such as heroin or cocaine, you can still get that charge. But for some reason, fentanyl doesn't exist in that charge. I put this slide up because Riverside County recently was our largest seizure of carfentanil. Carfentanil is an analog of fentanyl, and it is 10,000 times stronger than fentanyl itself. So you're talking 100,000 times stronger than morphine. Carfentanil, quite frankly, doesn't even have a human purpose. It's an elephant tranquilizer. But this is the type of stuff that is coming in and being used and cut and pressed into drugs. So I put all these things in there as a reminder of why we're doing this. I know that as Steve mentioned, one of the things that we need to change is this culture of ideology, that there are a number of people who believe, well, wait a minute, maybe they voluntarily took it. You can't do this to drug users. Why are we treating this when we have real homicides going on? Quite frankly, these are real homicides. The fact of the matter is that you have people who have no idea that they are about to die, that they are playing Russian roulette with their lives based upon a gun that someone else has loaded. With regard to the M30s themselves, there was a DEA study that showed approximately 26% of pills randomly tested contained a lethal dosage of fentanyl in them. Better than 1 in 4. The DEA updated those numbers recently in a new study that showed 42% of pills in a study they did had a lethal dosage. So we're talking anywhere from a quarter to a third to nearly a half of these pills having enough fentanyl to kill someone. For, again, the most common analogy that we've seen, not only from law enforcement, but more tellingly from users and sellers, is they understand that they're playing a game of Russian roulette. In one jailhouse interview, after a suspect the night before had been poisoned himself, he had furnished to his girlfriend, she was dead. He's now sitting in a jail interview room, and the thing that he was asked was, what are you going to do when you get out? And he said, the first thing I'm going to do is take it because I need that high. Don't get me wrong. There are people who will chase this as much as they can, even though they know that they're going to die. It is a game of Russian roulette. And in that classic game of Russian roulette, when you're talking about a 1 in 6 chance of the bullet being in that chamber, well, here, again, you're talking 1 out of 4 or 1 out of 3. You're talking about a fraction that is exponentially higher than a game of Russian roulette. This is an example of the pill press. Again, these are being demonstrated here. And one of the most easy descriptors I can give to you on why this is so dangerous, why these pill mills are so dangerous and these M30s are taking lives, is because there's no exact dosage in them. Think of it like a batch of chocolate chip cookies. Once the chips get poured in, you don't know if a cookie is going to have 2 chocolate chips or 12. And quite frankly, that is the issue with fentanyl. The people who are cutting it and pressing it aren't dosing it in any way other than to make them the most money possible. And it is a multi-million-dollar business. For an investment of a few $1,000s, you are seeing a return of millions. So let's talk about the charging options, what we are looking for. I'm going to start with Penal Code Section 187. When we have a dead body as a result of acute fentanyl poisoning, can we prove a murder? The questions we have to ask under the CalCrim, and CalCrim are the jury instructions. So the simplified explanation of what each of these offenses entails. We have to demonstrate under CalCrim 520 that the defendant committed an act that caused the death of another person, and that when the defendant acted, he had a state of mind called malice aforethought. Now, for malice aforethought, he intentionally committed the act. The natural and probable consequences of that act were dangerous to human life. And at the time he acted, he knew his act was dangerous to human life. But nonetheless, he deliberately acted with a conscious disregard for human life. Now, I know that's a little bit wordy. So one of my favorite condensed versions of this is I know my conduct is dangerous to others, but I don't care if someone is hurt or killed. So when we have furnishers who have previously overdosed or been poisoned, when we have furnishers who regularly keep Narcan in their home or on them, when they've had to revive their own girlfriends or loved ones, when there are a number of things that we can do to demonstrate that they knew the conduct was dangerous, but they didn't care, be it for the financial incentive, trying to have a sexual relationship with the other person. It doesn't matter what the reason is, as long as they threw caution to the wind, knowing the dangerousness of it. One thing that's been really interesting in talking with my colleagues has been, the questioning of, well, we're in a new area here. How's this all going to be taken under the law? Quite frankly, implied malice murder is not new. It's not only been around for a long time, it's accepted in every state in the union. Additionally, that case, People v. Watson, you can imagine that was a time before defendants were advised in court of the dangerousness of drinking and driving, which, by the way, the fact that we still have to remind people about the dangers of it is telling. But nonetheless, we are looking at something where, as long as we can establish that that person knew the conduct was dangerous and disregarded it, we can prove a murder. And one of the best blueprints for this is a case called People v. Sung. So hopefully this news clip will play through.
Good evening, everyone. I'm Susie Sung. And I'm Elsa Ramon. Our top story on KCAL 9 News at 8 in a landmark case that has been closely watched by medical professionals all across the country. A San Gabriel Valley doctor has just been convicted of murder charges for the deaths of 3 patients. Those patients died from overdoses. KCAL 9's Dave Lopez has reaction to this verdict.
My son passed away almost 6 years ago, and we've been waiting this long for justice.
And today, April Rivero heard the words that she has been longing to hear.
Guilty of the crime of murder in the 2nd degree.
Dr. Lisa Sung sat expressionless as the verdicts were read. Guilty of 2nd-degree murder 3 times. Guilty of prescribing a controlled substance in an illegal manner. 24 felony charges against her, 23 guilty verdicts.
I am so grateful to our prosecution team. We couldn't have asked for better support than we've had from the beginning on this case.
Her 21-year-old son, Joey, was a senior at Arizona State. He found out about Dr. Sung, who ran her office in Roland Heights. She was known as someone who would, quote, give a prescription to anyone. According to the testimony, she did just that, averaging 25 prescriptions a day, more than 27,000 prescriptions over a 3-year period.
And you still hold her completely accountable for this.
Of course I do. Naturally, these boys made perhaps the wrong decisions going to see her. You can't say that they weren't at some level, culpable, but it was said in the trial, addicts and people who are seeking these medications aren't in control of their thought processes.
The prosecution said that in addition to Rivero, there were 2 other patients of Dr. Sung who died as a result of her negligence, prescribing way too much Oxycontin or methadone or Xanax.
If you commit crimes and you are a doctor, you will be investigated and potentially prosecuted for those crimes.
And in the case of Dr. Sung, who was arrested more than 3 years ago, because of today's verdicts, she could get life in prison. Yesterday, on the 7th day of deliberations, the jury of 9 women and 3 men indicated to the judge that they were deadlocked on the issue of intent, the difference between 2nd-degree murder and manslaughter. So the judge allowed both sides 10 minutes to re-argue their case. And then today, the verdicts. When I asked the prosecutor if that second bite of the apple made all the difference, his response, I just argued the facts for 10 minutes.
And that case ultimately went up on appeal and it was affirmed. So we have precedent to say that a person who prescribes high doses and large quantities of controlled substances, such as opioids that lead to overdoses, when they have that knowledge of the dangerousness of it, can be convicted of murder. And here the evidence demonstrated that this licensed physician did have the subjective appreciation for the risks, and the implied malice 2nd-degree murder was warranted. So this is a great blueprint for anyone who's going back and looking to maybe talk to their district attorney's offices if you're not already prosecuting these cases. While not street level drugs, we do see that when a person knows the dangerousness of something like fentanyl, we have, again, a blueprint to go after them in court. All homicides do start as second-degree murders, but under Penal Code Section 189, there are certain instances in which a murder is first degree as a matter of law. Now, ordinarily, a first-degree murder is one where a person is willfully, deliberately, and with premeditation commits an intentional killing. However, certain examples exist where if the means of death are any number of these enumerated things, including the highlighted portion that you'll see here in gold, poison, it is first degree as a matter of law. This is an avenue that we are currently in Riverside County prosecuting defendants on. The people still must prove that the defendant acted with malice, either actual, express, or implied. But once we do that, once we demonstrate that in our cases, implied malice was shown by the defendant, the jury can then address the finding that the means of death was poison. As you see here from a case law, a defendant acting with implied malice who kills his or her victim with poison is guilty of first-degree murder, even if the defendant lacked the intent to kill. Because again, on a second-degree implied malice murder, we don't have to establish an intent to kill, rather that they understood the deadliness of the actions, but disregarded it. And so a poison, as defined under Penal Crim 521, is any substance applied externally to the body or introduced into the body that can kill by its own inherent qualities, which I don't know a toxicologist or a pathologist who has studied fentanyl who wouldn't say that, again, more than 2 milligrams, that is certainly something that will kill by its own inherent qualities. One thing, and the reporter in that news segment from People Be Sung got a little bit wrong, was it is the conscious disregard for human life that sets implied malice for the purpose of secondary murder apart from the gross negligence standard that we see for involuntary manslaughter. It's not necessarily intent, but better described as a specific mental state. So really, the question is, if we can't demonstrate that implied malice, that mental state, what are our options going forward? Well, we can move to involuntary manslaughter. You might notice that I skipped voluntary manslaughter, and the reason for that is the elements for voluntary manslaughter, when we're not talking about something along the lines of heat of passion or quarrel or imperfect self-defense, are actually remarkably similar to implied malice. So really, there's never going to be an instance where we're going to use that as a better alternative to second-degree murder. But nonetheless, for anyone involved in case negotiations who's here, it is a good tool for potential case resolution if that is being looked into. But nonetheless, when we're looking for a separate distinct crime, involuntary manslaughter is going to be one of our next possibilities. The defendant committed a crime or a lawful act in an unlawful way and acted with criminal negligence, and that act caused the death. Criminal negligence is defined as acts in a reckless way that creates a high risk of death or great bodily injury, and a reasonable person would have known that acting in that way would create such a risk. Now, let me tell you why it's an inadequate charge. The punishment is only 2 years, 3 years, or 4 years. The triad for Health and Safety Code Section 11352, which is furnishing fentanyl, is 3 years, 4 years, or 5 years. You get more time for the furnishing than you do for the death. And they are what's deemed 654. You can't be double punished for it. And you're also serving your sentence locally under 1170H. And the charge by itself is not a serious or violent felony, so it's not a strike. So we were looking for other sections that we could do that would have more teeth than an involuntary manslaughter charge. And one of the ones that came to mind was Penal Code Section 12022.7, which is the infliction of great bodily injury. I'm going to go through this quick to get through our time allotment, and this will be available for review later on. But it was actually a very smart idea that a number of law enforcement agencies and prosecutors tried throughout the recent decades, which was to affix great bodily injury allegations to charges such as to 11352. As we saw in People v. Martinez, the appellate court actually said it was okay. In that case, it was one where a person was administering drugs to a person who was increasingly intoxicated. Therefore, she was not voluntarily taking it. However, in a follow-up case, People v. Slow, that case was overturned as the appellate court deemed that a drug purchaser who purchased from a drug dealer and then went to his home and used at some later time essentially inflicted great bodily injury upon himself. So really there was a conflict in the law until this case, People v. Ollo. And I'll tell you, at the lower appellate court levels, the Ollo decision was actually very good for us. However, once it got to the Supreme Court, we really started seeing a decision that gave us some determination in when we could file these, but also hindered our abilities. And essentially, what we learned was the suspect must still have a personal connection between the overdose and again, the suspect. So really, it can't be that person who goes home and then uses later and essentially inflicts great bodily injury upon themselves. We have to see a personal connection between the defendant and the overdose. One of the key considerations was voluntariness. So they took that language from Martinez, and we had to have a fact-specific inquiry to determine if that was something that we could really find. Was the ingestion voluntary, or were other things present, such as administration? They didn't want to set strict liability for a drug dealer and the poisoning or overdose of a person who took those drugs. So again, it's a fact-specific inquiry on those facts to see if we have a lack of voluntariness or administration. And so they made a big difference between administration and simply providing the drug. So really, for a prosecutor who's out there, or for a law enforcement officer who is investigating this, we're looking to make sure that the facts come out in court that demonstrate that this wasn't just I sell it to you and you go home and use on your own, but there was something that possibly undermined the victim's voluntary choice. And I think the biggest question after Ollo, when it comes to fentanyl in particular, is considering that the most common ways that this is distributed nowadays is disguised as an oxy or a perk. Is that consumption voluntary? I would say no. And in fact, we're currently prosecuting a case with that very question. Additionally, if a victim takes an M30 pill and a furnisher provided without any modification, has there really been a break in the causal nexus? Because again, once that pill in the form it's in, the user really can't overdose on their own. They can't take too much. They can't take an amount other than that pill. And how direct must administration be? I don't have the answers for all these, but knowing this is what they're looking for is going to make your investigations easier. One thing that I'll run through really, really quickly is I actually think a novel charge on this, and we're starting to see this in Riverside County, and I hope we'll see it elsewhere, is potentially looking at it as an assault with a deadly weapon. Many of you are likely already familiar with the elements of it, but essentially it is, you do an act that you know is going to result in the application of force, which is just a harmful touching, and you do it with a object or an item that is either inherently deadly or is used in a deadly manner. And so with that, one of the most important things that I like about this as a potential charge is the fact that consent is not a defense to this charge. So really, it doesn't matter if a victim voluntarily took it. Again, that's actually not even going to be permissible as an argument. And quite frankly, it shouldn't be an argument in most of the homicide cases as well, but it is a unique way of looking at it. And I know that I'm excited for us to see more of a prosecution end on it. And additionally, we've seen case law that has said a battery may be committed by the administration of poisoning. So really, force doesn't need to be the classic punch, hit, or otherwise injury that we see from what we commonly associate with an assault with a deadly weapon charge, such as, I don't know, a knife or a gun. Very quickly, defenses, multiple drugs on a tox report, just like Steve said earlier, it's certainly something that they're going to make hay with, because we have to show that the act was the act of furnishing the fentanyl caused the death. But most importantly, as Steve said earlier, as long as we can demonstrate it's a substantial factor, we don't have to show that it was the only factor. I included some language in here. You should have copies of this PowerPoint, and we'll make sure that you can look at this. Again, an independent intervening cause is the only thing that will absolve the defendant's criminal liability. Might be criminally liable for a result directly caused by his act, even if there is another contributing cause. In California, it's well established that a crime victim's contributory negligence is not a defense. You may wonder, are these accidental overdoses? Quite frankly, under the Cal Crim, I believe it's 510, which instructs on accident, there is a requirement that it be a lawful act that is done in order for the accident jury instruction to be given. These aren't lawful acts of furnishing fentanyl. And quite frankly, even if the act results in a death that is accidental, the circumstances surrounding the act may evince implied malice. From one thing that is quite interesting, for those of you who've been involved in law enforcement for quite some time, there was a time when, under a theory of second-degree felony murder, drug furnishing charges were prosecuted as murders. Unfortunately, through changes in law, that is no longer the case. But there are certain defenses that have survived through their common law application. And one of them is that of a joint possessor. So essentially, if you have two people who equally pool their money, $20 and $20, they buy drugs and they each get half, well, there's an idea that you can't demonstrate furnishing to that person and they should be immune from prosecution for the evils that come with it. Nonetheless, while that is something you should know investigating these cases, like People v. Edwards told us, there are very few cases where there's going to be a true co-purchaser, because one person is going to be more involved in the acquisition or the maintaining, the financing, whatever it is, in getting the drug. So while it's a good defense to know to negate, the truth is it's going to be easy to do so. There are Good Samaritan laws on the books, but those only protect against possession for personal use. So if there's a question of, well, how do we go after these people if they call and report? If they furnish to someone, that's a completely different health and safety code section. Therefore, they are not protected under Good Samaritan laws. I'll go through it very quickly. The idea of like Steve said earlier, the scenario where a seller sells to someone and then that person gives a pill to another person. There are a number of prosecutorial theories that we can go under, both as a direct perpetrator and as an aider and abettor in an applied malice murder. Here is the language from a case, People v. Powell, that kind of demonstrates our ability to do so. And quite frankly, a jury can be instructed that a defendant is guilty either as an aider and abettor or as a direct perpetrator, and they don't have to be unanimous in which theory they're looking at. So that is it. Got in 1 minute under the 3 o'clock hour. There's probably some questions, but nonetheless, my information is right here, whether it is to make sure you get the PowerPoint or questions with regard to investigations that are either happening in your counties. Please don't hesitate to contact me.
Excellent. Thank you to our amazing speakers for that presentation. Now we'll take a few moments if you'd like to unmute yourself and ask some questions. This would be the great opportunity to do it. Excellent. Well, as we mentioned before,